on record in the meantime.
Milady, shall I go first?
Yes, you may.
Thank you very much, Milady. I'm appearing for the second respondent in the main application. The initials are AK. The surname is Kisun Singh. It's 2 words, KISSOON, leave a space, SINGH. I'm appearing together with my learned friend, Mr. V.I. Gaju SC, as I said, for the second respondent.
Your sound is very low. I couldn't even hear your name. So I'm going to ask you to just attend to your sound.
We will try and do that, Milady.
Okay.
Milady, I appear for the first respondent. The surname is Mtsweni, on the instructions of Messrs. MT Mokobela Incorporated.
Thank you, Mr. Mtsweni.
We're trying to adjust the sound, Milady.
Okay.
Milady, I'm speaking to you through my junior computer. Hear me now, Chowdhury RBG.
Milady, we're just trying to get the IT technician to come back. He's in the building. He'll be here in half a minute.
Okay. Okay, I'll just stand down for about 2 minutes.
Thank you, Milady.
Mr. Chowdhury, it looks like Mr. Chowdhury is still also sorting out his network.
Thank you, Milady. Here too.
I'm sorry, sir. Can you hear me?
David? David?
Yes, I can hear you.
Are we
I can
clear?
hear you.
Are we loud and clear?
I think you're better.
Huh? You're better. Is there any way else we can make it louder, because it's just gone away now? Just stick around here, please, if you don't mind. Right?
No problem.
Because I don't know what it is. Is it because the video was on? Put the video on. Is that the problem?
No, there's not a problem with it.
David, can you hear me?
Who's that?
Jesh Chowdhury.
Is that you? Is that you, Rajesh?
That's right.
Yeah, I can hear you. Maybe you must want to speak up as well.
Yeah, okay. Can you see me, David? Not yet.
No, I can't see you, but I can.
Okay, there we are. Okay, I'm going to switch my
Yeah.
own machine off and use my juniors. All right. It seems that there's something wrong here.
Gentlemen, can you hear us?
Yeah. Can
Loud
you
and clear, or is it a problem?
I can hear you, and I can see Vinay as well.
Okay, good. Then hopefully we've sorted this out.
Can you see me and hear me, right?
But that's all right. We can see you.
Okay, I'm going to ask counsel for the other 2 teams to place themselves on record. I've only noted the appearance of the MEC, KZN, Mr. Mtsweni. The other counsellor couldn't hear you when you were addressing me.
Thank you, Judge. Judge, I'm appearing for the applicant Chowdhury RBG SC, assisted by Advocate Bhimchand.
You are for the SIU. I prefer that you refer to the parties by their name. SIU, because there are 2 applications and the nomenclature is not the same in both. So SIU,
Very
Mr.
well.
Chowdhury.
SIU, correct.
Okay. Thank you.
My lady, I appear for the second respondent in the main application, that's VNA or Nexor.
Yes.
Initials are AK. The surname is Kisoon Singh, spelled KISSOON, leave a space, SINGH. I'm appearing together with my learned friend, Mr. V.I. Gaju, GAJOOSC, for the second respondent.
Thank you.
Lady, maybe it might be prudent that with the leave of my colleagues, I know we come in as the respondent. In normal circumstances, Mr. Chaudhry would have been the one to take a lead, but there is an interlocutory matter that we would like your ladyship to make a ruling on, and that is the application for the postponement of the matter by the MEC. And your ladyship would have noted that there was a substantive application for postponement. The application is not opposed by SIU, and procedurally so delivered what they purport to be their opposition basis, being a letter. The letter raises a number of technical points, which we will deal with shortly. And there's also another matter, your ladyship would have noted that there was a supplementary affidavit that was uploaded onto case lines, and that your ladyship would find under pocket 083. The affidavit is a supplementary affidavit. In the body of the affidavit, there are two matters addressed there, and the first issue is the leave. We seek your ladyship's leave to admit the supplementary affidavit, and we do so alive to the fact that our authorities are clear that we are only allowed to file two affidavits as applicants, that is the founding affidavit and a reply. Therefore, should we feel that there's a need to file a further supplementary affidavit in absence of a consent from the other parties, we can only do so with your ladyship's leave. We have addressed the reasons why what we seek to address in the supplementary affidavit could not be addressed earlier. In short, the supplementary affidavit just seeks to introduce one issue, one document. It seeks to introduce the confirmatory affidavit by Ms. Welilen Tuli. And the confirmatory affidavit only confirms what Mr. Makubela says in the application for the postponement, because when one reads the supporting affidavit, you would see that it is populated with a lot of what would amount to hearsay. That is the issues that Mr. Wise to what transpired in the department. So, my lady, we submit that having regard to the test that has been set out by our courts as to would leave to supplement, would submit that there is a good explanation. Secondly, there would not be any question of prejudice. We say that because one, the reason for the explanation is that why the confirmatory affidavit was omitted was that the application was prepared in a haste. And in doing so, we were not aware that we were belaboring under the impression that the matter was set down for hearing yesterday and today, as according to the notice of set down that we were instructed with. So, and the consultation took place telephonically with the witnesses being in Durban, in Maritzburg, and Mr. Makubela being up in Gauteng. So the affidavit, that's the long and short of it, that the application was prepared in haste, and so an omission was made to attach the confirmatory affidavit. As to the question of prejudice, my lady, will submit that there would not be any prejudice to either of the parties. As for Nexor, my lady, Nexor has taken a supine approach. They do not oppose the application, and insofar as the SIU might purport to want to oppose the application, my lady will submit that they have not taken up the olive branch that we extended to them to say they must file an affidavit. We were only given a letter. That letter cannot be the basis of any opposition because the rules are clear. Rule 6.5 tells us that should you not wish to file an affidavit and therefore, but you intend raising points of law, you must give notice, not a letter. They gave us a letter and we submit that. That's unprocedural. But be that as it may, my lady, they have not availed themselves to an opportunity to file an affidavit disputing what Mr. Makobele says in his affidavit. So in absence thereof, of any version that contradicts what Mr. Makobele says, and my lady, submit that there cannot be a question of prejudice. And for those reasons, my lady, would submit that as a housekeeping matter, we would ask for a ladyship's leave that the supplementary affidavit together with the confirmatory affidavit be that leave to file those documents be granted, my lady. On an assumption that your ladyship is with me on that question of the supplementary affidavit, we now tend to deal with the question as to why the MEC wants a postponement.
Okay,
lady,
Mr. Mutsueni, before you move on with the application, there's an issue I just want to canvass with you regarding the manner in which the SIU has mounted its opposition to that application, right? They have filed a notice of intention to oppose. Is that not so?
I have not seen the, if I can just go to the case lines quickly.
So they didn't just file the letter, they filed a notice of intention to oppose. And there's no provision in the tribunal rules for a notice to raise a point of law. So you seem to rely on the uniform rules of court. And my attitude is that that point is really technical. They've brought to your attention the points of law they intend raising. So in the interest of expeditiously disposing of this application, I'm inclined to allow them to argue those points.
We welcome that, my lady, but we will address those technical points in shortly, my lady, in the course of our submissions. My lady, if that being the case, may I then just address the question as to the postponement?
Not yet. Mr. Chaudhry.
Yes, my lady.
Do you oppose the leave sought to admit the supplementary founding affidavit?
I'm only hearing about it now, but we do oppose it.
Pardon?
Yes, we do.
You oppose? What are you opposing?
We're opposing well, first of all, the entire application, and
are you opposing leave to file the supplementary affidavit? You're also opposing that?
Yes, my lady.
Okay. Mr. Kisun Singh, I prefer that you are zoomed in, Mr. Kisun Singh, so that I can read your lips. That's much better.
We'll try and do that, my ladies. We'll have to get the IT guys back while you are listening to argument to see if they can do it.
It's much better. You have been zoomed in.
Thank you.
You're still a bit far, but it's better than earlier.
And unfortunately, my lady, we had to use these premises because of the generation capacity in case there were load shedding. Okay. My lady, we do not oppose either the application to introduce the supplementary affidavit or the main application of a learned friend for the MEC.
Thank you. Mr. Mtwe.
Yes, my lady. With that, my lady, I think I've dealt with the question. My lady, and so insofar as the question of the notice to oppose, my lady, I've just gone through case lines. I've not seen it, whether there was any notice of intention to oppose. The only notice of intention to oppose that I could see is the notice filed by Mr. Makubele on behalf of the MEC. As to whether the SIU has filed that, my lady, I cannot confirm or deny that.
Mbo, please assist me.
My lady, it has been filed yesterday together with the letter.
Yes, it has been filed. Yes, okay.
Okay. Lady, may I first deal with the question of the postponement and the what one would call the tried principles. We well aware that the question of postponement, it's a matter that is within the court's discretion, and the principles that govern whether or not the court should exercise such a discretion in favor of granting the postponement is a matter that had been canvassed by our courts, and the leading authority, my lady, is it has been known as the Myberg Transport case, which is the Myberg Transport versus Botha Trading as a truck bodies. It's a 1991 decision, which you'd find in volume 3 of the South African Law Report on page 31, where the courts laid down the following principles. The first mandate is that your leadership is vested with a discretion whether or not to grant or refuse the postponement. Secondly, that the discretion must be exercised judicially or not capriciously or upon any wrong principles. The third one is that the decision which your leadership will ultimately arrive at must take into account all the relevant facts and the principles, and that the postponement must be made timelessly as soon as the circumstance which justifies the application becomes known to the applicant. But there's a proviso there. It says where the fundamental fairness and justice justify postponement, the court may, in appropriate cases, allow such an application for postponement, even though it was not timelessly made. The next element that application must be made bona fide, but not made as a method to obtain to make as a technical maneuver. And furthermore, that the leadership must then weigh the prejudice that will be caused to the respondent if the application was to be granted against the prejudice that would be caused to the applicant if the postponement is granted. Now, lady, in dealing with these requirements, these principles, my lady will submit that the application hinges on two issues. The first, what are the reasons the MEC seeks the postponement? Secondly, what prejudice would there be to the SIU should the postponement be granted, and then equally, what prejudice would there be to the MEC should the postponement be refused? We will address that question in due course, because that question might need to belong in that argument. But my lady, what we say, and with my lady, there is no those allegations have not been refuted, is the following, is that initially the MEC had taken the preview. Your leadership would take judicial notice that there's been a regime change in the department, in that there's a new MEC at the helm who came in mid-year 2022. But the application itself, my lady, was issued in 2021. At the time, the head of the office was a different, the executive authority was a different MEC. Now, when the application was brought, the MEC took a decision, the then MEC took a decision not to oppose the relief suit. And on those bases, your leadership would have noted that the state attorney in Durban was appointed and that a notice of intention to abide was filed. That continued to be the position of the MEC during various pre-trials or case management meetings throughout these proceedings. But now things came to a head during the course of the previous year, after the MEC took over. Now, when the MEC took over, as it is practiced within government, that they would receive briefings as to what are the pertinent matters going on within the department. And amongst the pertinent matters that were going on within the department is the current application, which is, I would call it the consultancy agreement. Now then, the MEC, in order to decide whether to acquiesce himself with the decision of his predecessor, then sought the department, I would call the department being the officials' input as to what actually transpired in this application or in this, well, I would call it the tender process, which led to Nexor's appointment as the consultants in terms of the tender that is now sought to be challenged. Then, my lady, the MEC received the inputs and the views of the department as far back as March this year, towards end of March. That's what the instructions are. Now, what then at that time, then the MEC formed the view that he cannot sit back and not at least participate by filing an affidavit opposing the relief sought. So those bases would be canvassed in an affidavit that we would ask for leave to file. And then from there, my lady, that was in end of March. Then attempts were made to make contact with Mr. Mahluku, who was the attorney on behalf of the SI of the department, to say, well, Mr. Mahluku, we have since reviewed our stance and we would now like to participate seriously by opposing the application and filing an affidavit before this court, before this tribunal. And unfortunately, the contact could not be made with Mr. Mahluku, and then eventually that's when they turned to the state attorney in Pretoria, where they could get Mr. Chowe. And Mr. Chowe prepared because of the conflict of interest that might arise, because the state attorney, whether Durban, Pretoria, or Johannesburg, is on record for the SIU. Now, the MEC wants to take a stance that is contrary to what the SIU is seeking to do. And on those bases, that's when Messrs. The matter was then outsourced to Messrs. Makubela Tennis, who were appointed on a Saturday, and who immediately dispatched the letter warning everybody that the MEC has now changed his stance, and this is what he would like to do. He would like to oppose the application. And in that letter, your leadership would have noted that a cost tender was made. We will address the question of cost in due course. So, those are the reasons, in a nutshell, that the MEC is coming to you to say, I need a postponement. The MEC simply says, I want to participate. I want to file an affidavit. I want to put up facts before this tribunal, which facts would assist the tribunal in making a determination of this matter. And my lady would submit that is the high watermark of the MEC's case. So my lady then would submit that insofar as the question as to why was the application brought at the stage that it was brought, we submit that there is an explanation for that. It then, my lady, then brings me to the question of of prejudice. And my lady would submit that the question of prejudice must be viewed against the MEC's obligations towards this court, and as well as what the Bill of Rights says. My lady, your leadership would know that in terms of the Constitution says that the authority of the courts must be respected, and that government must take proactive measures to ensure that this court is effective. And how is the court effective? Is that the court can only be effective if, where government decisions are sought to be scrutinized, that the court is given the benefit of the department's view. And we submit that is one of the mechanisms through which the principle of court effectiveness can be attained. But secondly, Section 34 of the Constitution guarantees everyone, and we submit that by word everyone, not just anyone, but it also including the MEC and the government at large, of a right to a fair hearing by a tribunal. Now, encapsulated in the right, in that right, is the following. Firstly, it is the right to be heard. Not to be heard because what I'm saying is right or is wrong, but because that right is vested in me. And the court must be in a position, whatever nonsense that one intends saying, whether that nonsense, the court in making a decision must at least be vested with both sides. In other words, that the court's decision would have been, the tribunal in arriving at its decision would have been vested with at least both sides of the story and make an informed and to top it up, an unassailable judgment or order which takes into account the versions of all those parties concerned. Now, my lady, we submit that it is on those bases that we submit that the question of prejudice must be considered. It must be determined against the prejudice that would occur to the department if it's not afforded the postponement and even ultimately the leave, ultimately an opportunity to place its version before court, but also the implications on the administration of justice, insofar as this court is there to, this tribunal is there to dispatch of justice. So we submit that insofar as the department is concerned, we submit that the MEC would have now been gagged. We do appreciate, and we know that you go to be told that, well, the MEC had almost 3 years or 2 years to wake up and take a decision. Or you will also be told that, well, this current MEC cannot simply wake up overnight and devour the decision of his predecessor. He's bound by that. But my lady, we submit that that's not an administrative decision. If it was an administrative decision, I would simply say yes, that is correct. But this is not an administrative decision. It's purely a matter of a day-to-day running decision, if I may so call, which does not fall within the purview of an administrative decision, where one can simply say, well, if you come into the office and there was a decision made by your predecessor, you cannot devour such decision unless you get a court order that entitles you to devour that decision. The decision to change one's mind is one that is is made during the administration, not the administrative part, but in the administration of the day-to-day administration of the department. But coming to back to that question of prejudice, we submit that the effect is that, my lady, you've got a decision, you've got one serious allegations made in the affidavit against the department as to how the department went on a barrage of irregularities, all in order to favor Nexor. But those allegations don't just stop there. They now give rise to the fact that your leadership is being asked to say, well, whatever profits that Nexor had derived from this contract, Nexor must pay back. And we submit that for your leadership to make that determination, your leadership cannot make that determination one-sidedly, only with the SIU and Nexor and Nexor's version, because we know that although Nexor has tried to go tried as far as it can to put up a resistance on the merits, your leadership must also hear the department, because it is the department that took a decision. It was the department that went on an administrative process. What the SIU is telling you is based on on the opinions it formed from what it calls its investigation. But that cannot just be the basis on which this court should do. So, my lady, would submit that for those reasons, if your leadership was to decline the postponement, your leadership would have, the prejudice that would be on the department is that ultimately the department would have been gagged and would have been prevented from at least placing its side of the story before this tribunal, which coming to the next point would have deprived the leadership of a golden opportunity to make an informed judgment. And we say informed judgment taking into account the implications. This is a more than 2 billion rands contract. It's got implicated with which Nexor had invested substantially into, and the department had invested both as well substantially into it. And you're now being asked to undo that. And we submit that my lady, will have far-reaching implications even to those that Nexor had subcontracted or those that Nexor had engaged in order to deliver on its mandate in terms of the contract. So, my lady, having that, my lady, to submit that the administration of justice, the interest of justice warrant that your leadership should at least be afforded that opportunity with full facts to make that determination. So, my lady, we submit that for those reasons, my lady, there is a proper case that has been made out by the department. And my lady, was coming also before I round off. We know that the matter has been running at least for 2 years, and it has taken serious interventions by leadership to make sure that the matter at least comes to light. And it was set down for 2 days. We will be told that, well, this matter is good. This will just further and inevitably delay the matter. My lady, we submit that to deal with that, my lady, your leadership can, and leadership has got the powers to put up a structural order which would ensure that one, the whatever papers or steps that the MEC wants to do, that is done quite effectively. And we had said that in our notice of motion that at least leadership can put us to terms that whatever documents that the MEC wants to file, he must do so within 20 days. Following that, my lady, leadership can then put up all the other timeframes for the exchange of further documents or convene a case management upon the receipt of those documents in order to facilitate the further conduct of the matter. But we submit that, my lady, is a matter that is within your leadership's discretion. But it will also go a long way to demonstrate that the MEC is not seeking to delay the matter. The MEC is seeking to just put up his version before court. But equally, my lady, you're going to be told, well, that Nexor's contract is coming to an end of April. That is correct. But, my lady, nothing stops your leadership in terms of section 172(1)(a) to make, if your leadership finds that the court was unconstitutional, from declaring as such. That, my lady, can happen even post the decision. So it is not an order that it is not a question that if your leadership was to make such an order in due course, that order would not be worth the paper it's written on. It will still be effective. Insofar as the question as to what then happens to that, my lady, we know that section 172 does not bar leadership from making various orders for as long as the orders would give effect to the declaration, but also taking into account the various interests. It's a discretionary matter. That is section 172(1)(b), 72(b) of the Constitution as to what would be just and equitable. So, may we submit that whether the order is granted today or is granted tomorrow, it will still be effective and will still be able to be given effect to, because, my lady, insofar as the question of whether Nexor should pay today or should pay tomorrow, you have not been told that Nexor is insolvent or Nexor might not be able to honor whatever order that your leadership will ultimately make. If you find that the principle of no profit should apply, and therefore Nexor should repay all whatever has been paid. You have not been told that. So we submit that there's no prejudice on the SIU that we will not do that. If we not had today, the order that we'll get tomorrow would not be worth the paper it's written on. So we submit, my lady, that still tips the scales in favor of granting the postponement. Now, my lady, it then brings me to the question of costs. My lady, we had made a tender of costs, and save for the question for the SIU, we submit that if the cost order is made in favor of the SIU, it comes from the same coffers. So there might not be a need insofar as the leadership can need to make a cost order insofar as the SIU is concerned, because it'll be money coming from the right pocket into the left pocket. So it won't go any far. It then comes to the question of the cost insofar as Nexor is concerned. In their letter, Nexor says that they would like the cost order to be made on a scale as between attorney and client. But my lady would submit, and the reason that is advanced is simply say on the basis of belatedness, my lady. But we submit, my lady, that is not the test which has been laid by our courts for such a cost order, because what the test that was laid for such a cost order, appreciating that that your lordship has got a discretion, the test that your lordship should apply in determining whether such cost order should be made, we would ask that your lordship has regard to what was said by former Chief Justice Mogoeng in the Public Protector versus the South African Reserve Bank. That is a 2019 decision, volume 6 SA 2253, the Constitutional Court decision, where Justice Mogoeng said at paragraph 8.
Paragraph?
Our court, paragraph 8.
Thank you.
Ours are courts of substantive justice. No litigant ought to be left exposed to an undeserved ruination just because she did not expressly plead non-compliance with legal requirements that are very loud in their cry for attention of lady justice. Costs on attaining client scale are to be awarded where these are the factors: fraudulent, dishonest, vexatious conduct, and conduct that amounts to an abuse of the process. Now, my lady, for the fact that the MEC brought the application at the late stage does not fall within those categories. At least if
is that list exhaustive, Mr. Mutsuin? Is that list exhaustive? Given that when making an order for costs, the tribunal would be exercising a discretion. I'm not limited to the factors I would take into account.
We will submit that it is not exhaustive, but is guiding. That these are the matters which our courts have largely made reserved cost orders on an attaining client scale. So the fact that the MEC has brought the application belatedly so is not a factor on its own. Because what the leadership should also take into account is the explanation. Because even though the application might be belated, which is a factor with a question that must be determined taking into account the circumstances of the case. Because one cannot simply say because you had from 2021 till today, therefore you are late. You must take into account what the explanation that is given by the MEC. So we'll submit that the belatedness of the application.
Okay, let's deal with the
I'm there, my lady. I'm listening.
I'm saying I'd like you to deal with the period between March this year and now, right? Because on the MEC's version, you didn't disclose the date. On the MEC's version, she took the position in March, sometime in March, to enter the fray.
Yes.
That's the earliest she ought to have advised the register of the tribunal as well as the parties of, I'm not sure if it's a female or a male, he or she intends entering the fray and applying for a postponement. Now, this application brought this late, assuming I'm sympathetic towards his or her cause. It's clearly inconvenient that it's brought this late. Nexco has incurred the costs, extensive preparation costs to be ready for the application to be argued. The tribunal has accommodated it at the expense of other matters. And it's an issue, this lateness, I strongly frown upon. And for that reason, it deserves deprecation by a way of a punitive cost, but also under the circumstances when viewed holistically, I am not persuaded that Nexco should be out-pocketed. Nexco is ready to proceed.
We're not saying that Nexco we're not saying that Nexor should be out of pocket. What is an issue between us and Nexor is the scale. And we do this alive to the
But
fact
that's exactly what I'm addressing, right? Party, the scale you've tendered does not fully compensate Nexco. So if I allow costs on the scale you've tendered, Nexco will be out-pocketed.
Well, my lady, we cannot, all that we were saying that in consideration that because the Nexor had said that the only basis that they seek cost on a punitive scale is the belatedness. But
Yes.
Malady, what we say, Malady, is that yes, your leadership is quite correct. The earliest that the MEC ought to have taken steps was in March. But what the MEC says in the affidavit is that I tried making attempts to get hold of Mr. Matluku because we were not advised that Mr. Matluku is no longer with the state attorney, so that we can provide him with the appropriate instructions. And when we realize that we are not getting hold of him, that's when we then turn to the state attorney's office and talk.
Those are all internal factors.
Yes,
as a result of which I don't believe Nexor should be out-pocketed.
Yes, but what we are saying is that your leadership, we are alive to the fact that your leadership has got a discretion. But what we're saying is that in determining whether Nexor the cost should be paid, the Nexor's cost should be on an attorney and client scale, that's a factor that your leadership should take into account, and we will not take it further than that. And as to whether the cost, my lady, we know that Nexor has engaged 2 prominent senior counsels. 2, not just 2 silks, prominent senior counsels of years of experience. I know Mr. Kaju, or Mr. Kaju and I have had our time between courts. I've had the benefit of being in the same matter with Mr. Chowdhury. The only person I've not had an opportunity to be in a matter with is Mr. Kisum Singh. But Malid will submit that even though it was a 2 billion rand claim, the question is, did it warrant 2 senior counsels?
The matter is highly technical. I've actually sought more time to study the papers because I needed to fully understand the concepts so that I can fully understand both the SIU case and the defense mounted by Nexor. Clearly, the area is quite, there's a lot of innovation that has, taken place in the subject matter of the contract. So it is quite technical. Factually, it is complex, and the value of the contract is also quite high. I don't think Nexor was unreasonable in employing 2 counsel here.
Well, that's as far as I can take it insofar as the question of cost is concerned. But primarily, my lady, would still ask that your leadership grants the postponement sought, and my lady, that we're open to leadership putting us on terms as to how we should then proceed with the filing of the documents going further. So those would be our submissions insofar as the request for postponement.
Another reason why I'm not sympathetic with you on the question of the scale of costs is that if in the event that I grant the postponement, I'm actually doing this at great risk because the MEC has not disclosed the basis for opposition. I don't know what she's coming to say. So I think one issue that would make me strongly consider granting the postponement is the fact that this party is a decision maker and its decision is impugned, and it's in the interest of justice that it places a version before yes. The tribunal. Yes. But I have no idea. And I mean, having read the papers, the manner in which both the department and the SIU seem to have dealt with not only this application, but the application that Nexor brought before the KwaZulu-Natal High Court when the department had served it with a notice to terminate the contract is most bizarre. So, the circumstances are such that this tribunal will greatly benefit from the MEC placing a version before it. Yes. But I do so at risk because I have no idea what the MEC is coming to say. And I'm not persuaded that even though the application was prepared in haste, the MEC could not have articulated its position in 1 or 2 paragraphs. It had almost 9 months to consider this matter.
Yes, Malady, I accept that, but Malady, what your leadership is quite correct is that your leadership can benefit, and we submit that if that the risk, this is one risk that Malady will submit that is worth it, Malady, in the interest of justice. So Malady, that's as far as we can take it. Malady, now if I had almost forgotten to address the matters that are now going that the SIU seeks to attend to. The SIU Malady seeks to now.
No, you'll do that in reply. If you've been arguing for almost an hour, Mr. Mutsu. This is a simple postponement application. I think rather reserve that.
Okay, Malady. So
when you reply, to deal with when you reply.
I'll deal with it in reply, Malady. So Malady, that's insofar that so those are submissions in favor of the postponement, Malady.
Thank you.
Unless there are questions that your leadership will, I'll address others in reply, Malady.
Mr. Chaudhry.
As Malady pleases. Malady, what Myberg, the judgment referred to by my learned friend, it's a well-known staple in these cases. And what is required is a holistic view to be taken, but ultimately the question of prejudice is something to be considered. Now, your leadership has quite correctly put your finger on the nub of the issue. What is the MEC going to say? The MEC appears to be dancing on eggshells and skirting the issues. There's a whole history of what happened and where it happened and who took over and so on. This is at least 3 MECs ago when this happened. But we still don't know why the MEC, who is the party here, not the department, why the MEC took a supine issue almost comatose. And we might have used the phrase somewhere, I think we did, to say that what Nexor was doing was operating here as some kind of ventriloquist speaking for the department. And the department, or rather for the MEC. Now the MEC must have read these papers, must know what is being said about the MEC and the department that's controlled by the MEC, or the head of which the MEC politically is in charge. We don't know, and we still can speculate as to what the MEC wants to say. Does the MEC want to say, yes, he or she supports everything that's being said by Nexor? Or does the MEC say, yes, there are bits and pieces that are controversial, and we join issue with the SIU, or we support the SIU? We don't know. It's guesswork. It's really unsatisfactory. And this is where an indulgence is being sought from the court, from the tribunal, and one would have expected that as a matter of bona fides, the MEC would have said more than it has chosen so far. It's actually silent on crucial aspects. Point that has emerged, my lady, is that we don't know where's the authority to speak on behalf of the MEC in this matter coming from. The DG and the MEC are separate entities. The MEC doesn't appear to have delegated any authority to anybody to come before your ladyship and make affidavits or say things to the court about his or her case. And substantially, a lot of what has been said is hearsay. What the attorney for the MEC has been saying is based on what he may have heard from others, because admittedly he's come into the case very late, and therefore he must be relying necessarily on what people have told him. But we don't know who's told him what. So it's a lot of guesswork again in that respect. The delay, as I said, I'm not labeling the point, my lady. We know that the MEC came in, current MEC came in the middle of 2022. Now, I don't know how many contracts in this department controlled by the MEC run into billions of rands that are under attack. This must be probably the only one that's made the news in such a big way, that a contract running close to 2 billion, if not more, is being challenged, and the MEC would have had his or her antenna tingling, and alarm bells should have been ringing from at least 8 to 9 months ago. What's this all about? Why is it being challenged? Who can tell me more about this? Does it take 8 to 10 months to get the facts together? Even putting in a short affidavit in the interim saying, these are the facts I've gathered, I've just come into the picture now, and I'm busy assimilating my information, but so far this is what I want to do. I want to either challenge or I want to confirm the contract and say that the SIU is speaking a whole lot of nonsense here. This is a valid contract, but we know nothing. It's a matter of speculation, and there's no explanation given by the MEC for that. Now, The issue of good cause is linked with what sort of attitude does the MEC want to take? How long does the MEC want to garner information to place before your ladyship? Who's going to say things on behalf of the MEC? We don't know again. I know this is a new political head of the department, but we also know there's been comings and goings in the department. The two Nkosi's have been fingered, if I may call it that. We know, and I'm sure my learned friend, Mr. Kisun Singh, will inform you in due course of their fate. Have they been promoted? Have they been disciplined? What's going on with them? But the MEC should have been diligent enough to have checked into those factors, because these are two principal parties. That's the Nkosi's. Both of them, I don't believe they're related, but both the gentlemen have been mentioned like confetti in this case. And the MEC ought to have found out, well, what's going on here? And I want to say something about this. And he seems to have even
but
now.
Mr. Chaudhry, given that the MEC is the decision maker, is that the reason to really shut the door on him or her? Obviously, there is a concern that he or she is silent on what she's coming to say. But is it a reason to shut the door on the MEC? Particularly because the SIU itself is accused of relying on hearsay evidence regarding the actual tender process, what transpired within the various bid adjudication committees. The SIU is being accused of suppressing the evidence of Mr. Nkosi, who is a departmental official who was involved in the procurement process. Do you think, under these circumstances, even though the MEC has not said anything, as the decision maker, should be shutting the door on him or her?
My lady, at this late stage of my career, I don't want to sound obtuse. I take the point of what your ladyship is saying and where this is going. But, my lady, as a matter of responsibility, yes, your ladyship with respect is quite correct. MEC has a very important job, political appointment. The MEC has a great deal of responsibility to the government in the province, to the taxpayer, and so on. Now, our complaint is, my lady, that yes, there's a new MEC who came in. What happens if this MEC is fired or is transferred, or what happens? Somebody else comes in. There might be another.
So I think we should cross that bridge when we get there. There's another point that Mr. Mutsweni raised, which supports, which further justifies allowing the MEC to enter the fray, and that is, when determining just and equitable remedy, and my experience in matters of this nature before the tribunal also attests to the fact that the SIU is often not in a position to address the tribunal substantively on the just and equitable remedy, simply because it is not the department, it's simply an institutional agent. So apart from the fact that departmental officials, and I would expect that they would support they would be involved in the MEC's case, would have first-hand knowledge of what transpired during the procurement process. But as to what remedy would then be just and equitable, the tribunal will greatly benefit from the MEC's version.
My lady, I accept that. I don't want to be seen as being obdurate and not making a reasonable concession. That is true, my lady, and the MEC would understandably and hopefully, we don't know, we can only live in hope, that if the MEC is going to enter the arena, well, is the MEC going to add any value? And I suppose we will only know that once the affidavit from the MEC has been deposed to and filed. But I just say this much only, my lady, that at this stage, coming on the verge of entering the threshold, rather, one would have expected a little more from the MEC if the MEC was approaching this matter with a degree of candor, to take the tribunal into his or her confidence and say to the court, this is why I want to enter the arena. And files an affidavit that's denuded of that vital information. So here we are, certainly as a SIU, speculating, and as your ladyship might also, in as much as your ladyship with respect might want to hear from an MEC, given the responsibilities that are vested in the MEC, we are still at the stage where we are guessing. So, my lady, I'm not going to labor the point, except to say this much, that we don't know prospects of success when indulgences are sought or to be disclosed to the court, if there are any. And in this case, we're not talking about prospects of success really, but just a degree of a candid approach which the MEC should have adopted. And in regard to prejudice, my lady has already mentioned in the debate with my learned friend that this matter has been waiting for 2 years for resolution. We don't know how much longer it's going to take. Your ladyship has had to shuffle the role in order to accommodate this case. And your ladyship has mentioned the case in Pietermaritzburg. Regrettably, I wasn't involved there, but it is another aspect of the case, another dimension, which probably may or may not surface in the hearing at some stage. But my lady, insofar as your ladyship has mentioned the debate with my learned friend about costs of DNA, it doesn't necessarily mean vis-a-vis the SIU that we are all getting costs from one bucket or one pocket. So taking it from the right-hand pocket, putting it into the left hand, if an order for cost is made, doesn't necessarily ring true, because the SIU, like every other entity in the state, operates with a budget. Now, its budget is being denuded and dilapidated and decreased by the reason it's been this is an expensive case. And if it's going to keep accommodating people like the MEC who
I don't think Mr. Mutsweni, in fact, when he argued that point, I wished Mr. Andy Mutibi was in the room, because I know he's always complaining about how he's battling to recover the SIU costs from the department. So I am aware that they don't come from the same kitty.
Thank you, Milady. In fact, Milady, last week, or a few weeks ago, we attended a talk by the Solicitor General, who was making similar points about funds being low, and he seemed to suggest much to
but the SIU does not tax its cost orders in the tribunal, so I tend to be not too sympathetic towards them about costs, because they never collect them.
Well, I think my junior and I will have to be much more sterner with our principals and say, why aren't you guys taxing your costs? Please do so. But, my lady, I'm not going to labor the point. I've said as much as can be said.
Okay, let's deal with the issue of prejudice. I just want to get your view on, issues that Mr. Mutsweni raised, but not as direct as I'd like to debate with you. This contract comes to an end in about 2 weeks' time. So it's run its course.
Correct.
Almost. The SIU, after the proclamation authorizing it to investigate the contract was published, did not interdict the further implementation of the contract. It didn't interdict further payments. And in fact, when the department belatedly took the view to terminate the contract, it didn't even oppose. It filed a notice to abide the decision of the Pietermaritzburg High Court. If this matter is delayed by another 2-3 months, what prejudice is the SIU really complaining of here?
Well, my lady, you've identified a number of regrettable, what I might call lapses. There may have been good reasons for those, but your ladyship, with respect, is correct. Those lapses were not pursued, unfortunately, for whatever reason. But, my lady, if it does transpire at the end that these contracts have to be rescinded or refunds have to be effected to the Treasury, to the state, we can only speculate as to the financial state of the...
But the SIU, the SIU was not without a remedy to secure its rights. It has not exercised any of them, as I've said. So it's too late to complain of that prejudice now, when this contract is almost at the end.
Well, we're in the court's hands on that, my lady, and the ladyship has identified a number of serious points here in relation to those. The only thing I can say, my lady, is we are in financially parlous circumstances in the country right now, and we don't know if we do succeed eventually, whether or not those funds will be able to come back. The sooner one knows, the better. But right now, any delays will probably be to the prejudice. If the SIU is to succeed, it will be to its prejudice in trying to get funds back. Those are submissions.
Okay, Mr.
We are still seeking
I'm inclined to reserve costs of this application as against the SIU, because I think the costs ought to be considered holistically with the costs of the main application,
except
as against the SIU. Yeah. And I don't think the SIU will be prejudiced by that if I simply reserve the costs of this application is against the SIU.
Well, with respect, that is a matter of common sense. That's right, my lady. It would reservation of costs allows us to have another bite at the cherry in due course. The only point I can just say in that respect, my lady, is we've been brought here with another delay occasioned by the MEC, and there should be consequences of that.
Anything further?
Those are our submissions, my lady.
Okay. Mr. Mutsweni.
Yes, my lady.
It looks like this matter is going your way as far as the postponement request is concerned. So I'm going to limit you to reply in relation to the scale of costs. Okay. Let me just check if Mr. Kisun Singh would like to address me. Sorry.
Not at all, my lady. I'm not going to waste the time of the tribunal, my lady, with arguing as to why the MEC should be given permission to join. I can just refer your ladyship, if you want, to paragraphs 112 and 113 of the SIU's heads of argument, wherein they complain and then deprecate the MEC for not joining in and placing the position before the court. And at that particular juncture, one is now nonplussed as to why they don't want the MEC who's now come to court and is going to be punished because of lateness with orders for costs. As far as the other aspect is concerned, my lady, you are quite right. The contract is almost over. What is striking in this matter is not only did the SIU not go to court to interdict the contract or proceeds, but there's not even one suggestion in the papers that Nexor cannot pay back the monies which it is still earning in terms of the contract. As far as our costs are concerned, my lady, we would ask your ladyship to grant us the attorney and client costs. My lady, we have done extraordinary preparation on very complex issues in the last week and a half, and had we been told 2 weeks ago, we would not have incurred these costs. 2 senior counsels were brought in, my lady, because of the fact that not only were we battling against technical aspects raised by the SIU, some of which was out of our knowledge, but we were also faced with a barrage of applications to strike out matters which we were placing before the court as to why we are not guilty of any untoward conduct, or why we should not be ordered to disgorge profits if the contract is set aside. It required seriously the efforts, as your ladyship will note in due course when the matter is heard. My learned friend Mr. Gaju is going to deal with the various points in Limine and the strikeouts, which run literally, my lady, into dozens and dozens of pages, and then leaves us with a decimated affidavit. And at the end of the day, what the SIU has said is that we have arrogated unto ourselves the right to speak to the department. And I take your ladyship's point that it might be going the way of the MEC. We would simply persist with our claim for costs, which we would not have incurred had we been told even 2 weeks ago that the MEC wanted to join in. Thank you.
Thank you, Mr. Mutsweni. Just on the question of the scale of costs, please.
Lady, I think I would not, we would take note of insofar as the Nexor is concerned, my lady, I think we've made our submissions, but insofar as the SIU is concerned, I think your leadership's approach is quite most prudent under the circumstances. My lady, although yes, I accept that the SIU complains that it struggles to recover. The question is, my lady, what did they do that to recover? But because the leadership has told us that they do not tax those costs. But we still maintain, my lady, whether they come from this bank account or from that bank account, it's still like putting the money from the left pocket into the right pocket, because it all comes from the same fiscal, although different vote accounts.
Yes,
So
but I'm
we'll submit.
reserving those costs. I'm reserving
Yes.
those costs. So deal with
No, my lady,
Nexor's case.
yeah.
Yes.
Yes, my lady. So we'll submit, my lady, that insofar as Nexor is concerned, we'll leave the matter of the question of cost in the leadership's hands. The scale, although the costs are tendered, the question of scale is your leadership's discretion. But insofar as the SIU is concerned, my lady, submit that the costs ought to be reserved for determination at a later stage, my lady.
Thank you. We've come to the end of the proceedings. The registrar will upload the order on case lines as well as email it to your attorneys. Thank you.
Thank you, my lady.
As your ladyship pleases.
As your leadership, please.
As the lady pleases.
Gentlemen, thank you very much.